proper convening of a general meeting is a fundamental pillar for the validity of company resolutions. However, dilemmas frequently arise that, fortunately, case law has been resolving, providing legal certainty to these operations. One of the first questions that arises is, when should a defect in the notice of the general meeting be alleged? Case law is clear. Any violation must be reported at the beginning of the meeting. Failing to do so at that moment and attempting to challenge the resolutions later is considered contrary to procedural good faith. Another point of interest. Is it considered a defect that invalidates the meeting if the nature of a meeting is incorrectly named, ordinary instead of extraordinary? The Supreme Court has established that the mere naming does not invalidate the effectiveness of the resolutions given the absence of substantial differences between both types of meetings beyond their periodicity. A recurring aspect in practice is the figure of the convener. We ask ourselves, must the chairman of the board convene the meeting? The answer is no. It is the administrative body collectively that has the non-delegable power to convene the general meeting. The chairman simply executes that agreement. If the person convening the meeting has an expired term, is it also void? Case law, for the sake of the principle of business continuity, recognizes that those who de facto administer with an expired term have the power to convene a meeting aimed at regularizing the company's bodies, thus preventing its paralysis. Clarity in information is vital. The question arises, how should the agenda for the notice of a general meeting be drafted? It is imperative that it be clear and allow the partner to be aware of the matters. An incomplete or ambiguous agenda vitiates the notice and affects the validity of the resolutions, as it impacts the essential rights of the partner. It is often questioned, can any matter not included in the agenda of a general meeting be discussed at the meeting? Unless the meeting is universal or for the removal of directors, the Supreme Court's answer is a resounding no. The resolutions must relate to the matters previously announced. Finally, in situations of absence or conflict, in the absence of the secretary due to force majeure, can the legal advisor act as secretary at the meeting? The certifying authority rests with the secretary and the chairman. Substitution by a legal advisor does not replace the signature obligation that guarantees the veracity of the content of the minutes. And if there are two different drafts of the minutes, what happens if there are two different drafts of the minutes? It is advisable to ratify the resolutions in a new and immediate general meeting to avoid disputes over the veracity of the content. In the next video, we will analyze 5 common confrontation scenarios in meetings with a notary present and how judges resolve them. Focus your queries and challenge our AI Atenea. Complex questions, expert answers. More information at ilpabogados.com.